of freedom. Just like as I said, today being 11th day of January 2026. This is Kofa da Ramiya roundabout to Sokoto. So the challenges we are having is that the judgment of the court is really affecting Mazi Nnamdi Kanu's appeal. Remember that the judge ordered that Mazi Nnamdi Kanu should not have electronic access to electronic devices. And somebody who is doing an appeal on his phone, he cannot. Even the correctional center, when the Mazi Nnamdi Kanu wanted to go and do something, they said that no, the order said that he should not have any electronic device. How can you say somebody who is doing his appeal, he cannot have access to printer, he cannot have access to photocopier, he cannot have access to any electronic gadgets? It is unfair.
Hello my people, welcome back to Africa Rise. This is a first-hand report from inside Sokoto, straight from one of Nnamdi Kanu's lawyers, and what it reveals raises serious questions about fairness, due process, and the true meaning of justice. Kindly watch this video to the very end and tell us where you are watching from in the comments section below, because this update is one every lover of freedom needs to hear.
You don't do this kind of thing. Now, the consultants, most of the consultants and the people, the sympathizers, the experts that have sympathy for him has given me their various contributions in their bill. You can see it. Now I'm giving him the hard copy. It is now left for him now to see all these things, put it together, and he print it out and sign and file his appeal. But he cannot do it. I just gave him the hard copy. He was telling me the challenges he's having. Today is the 11th day of January, and the judgment was given on November, and he cannot file his appeal. I have not seen this kind of judgment in my life.
Nnamdi Kanu's lawyer, Barrister Maxwell Opara, paid a visit to him in Sokoto, not for politics, not for agitation, but for something basic, humane, and legally necessary to check on his well-being and to sit with him in preparing the materials for his ongoing appeal. What he encountered was deeply troubling. According to Barrister Opara, despite the already heavy burden placed on Nnamdi Kanu's appeal by the most recent court judgment, new restrictions have now made the situation even more severe. The court's decision has effectively barred Kanu from accessing any electronic device whatsoever. No laptop, no printer, no digital tools of any kind. Now pause for a moment and think about this carefully. This is a man expected by law to prepare, harmonize, and file his own appeal. Yet the very tools required to do so have been completely denied to him inside Sokoto prison. In practical terms, this makes the preparation of his appeal almost impossible. Barrister Opara described it in the clearest terms possible. It is like cutting off a bird's wings and still demanding that it must fly. This is not just harsh. This is not just inconvenient. This is fundamentally unjust. Over time, concerned consultants and sympathetic legal practitioners from within and outside Nigeria have worked tirelessly, contributing legal arguments, research, and materials in support of Nnamdi Kanu's appeal. These contributions are not lacking. The legal substance is there. What remains is for Kanu himself to carefully review these materials, harmonize them, make necessary adjustments, and formally file his appeal as required by law. But that final step has now been turned into an uphill battle. Barrister Opara confirmed that he handed over hard copies of these legal contributions to Kanu during the visit. Yet, instead of relief, what he saw was deep frustration and visible concern. Reading hundreds of pages of legal documents manually, cross-referencing arguments, editing drafts, and meeting strict timelines all without basic tools is not a reasonable expectation. It is a deliberate constraint. And this is where the issue goes beyond politics and enters the realm of fundamental rights. The principle of fair hearing is one of the pillars of justice. A person may be detained, tried, or even convicted, but the law still demands that such a person be given reasonable opportunity and means to defend himself. Justice cannot exist where a man is denied the tools required to speak in his own defense. Barrister Opara was clear on this point. He described the restriction as a clear violation of fair hearing and confirmed that the legal team is now considering returning to court to challenge this condition once again. This is important because appeals are time-bound, deadlines are fixed, procedural requirements are strict. When access is delayed, justice itself is delayed, and when delay is intentional, justice becomes denial. What makes this situation even more concerning is the broader context. Nnamdi Kanu's case is already under intense national and international scrutiny. Questions have long been raised about due process, prolonged detention, and compliance with legal standards. In such an environment, one would expect extra care, transparency, and restraint. Instead, what we are seeing raises fresh concerns. Barrister Opara said he felt a strong moral and professional responsibility to share this update with lovers of freedom all over the world. Not to inflame emotions, but to prevent silence from becoming complicity. Because history has shown us this simple truth. Silence in the face of injustice only strengthens oppression. This is not about whether one agrees or disagrees with Nnamdi Kanu's political views. That is not the issue here. The issue is whether the legal system allows a man to properly access his right to appeal without artificial obstacles. Today, that question remains unanswered. And this is why this update matters. When a detainee is isolated from the tools of defense, when legal preparation is frustrated by administrative barriers, and when appeals are weighed down not just by law but by restriction, it sends a message not just to one man, but to the entire system. A system is judged not by how it treats the powerful, but by how it treats those in its custody. Africa Rise wants to be very clear here. We are not announcing outcomes. We are not predicting verdicts. We are not spreading false hope or unnecessary fear. We are reporting a documented visit, a first-hand legal account, and a situation that raises legitimate legal and human rights concerns. What happens next will depend on how institutions respond. Will the restriction be reviewed? Will access be granted? Will the appeal process be allowed to proceed fairly and meaningfully? These are the questions now before the Nigerian justice system. For Biafrans, Nigerians, and observers around the world, this moment calls for calm vigilance.